And I did record the.
That are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call. And no, I'm not.
You know what, Mr.
not,
you might as well stop right now.
I have the text
because
message.
no, I'm going to tell you. I don't know if you're misunderstanding something or what. I'm not going to believe it, and I'm not going to hear you. I'm not going to hear you. I don't know what you How do you not understand what I'm telling you?
Listen,
you don't know what? That's the third time you've done it. You're gone, Mr. Allen.
This entitled Brad walked into court armed with nothing but lies and delusion, and somehow thought it would work. From the very beginning, this hearing was a mess, and it only kept spiraling from there. He's facing charges for assaulting a witness. But instead of staying quiet and letting his attorney handle it, he decided to take matters into his own hands. He allegedly contacted the witness's attorney directly and tried to strike a deal to stop the witness from testifying. Which, just to be clear, is about the worst move you can make in a situation like this. And if that wasn't bad enough, he didn't stop there. He then went on to file charges against the same witness, clearly trying to flip the entire case and paint himself as the victim. At that point, it stops looking like confusion and starts looking like manipulation. This is easily one of the most chaotic hearings I've seen in a while. Nothing is clean, nothing lines up, and Judge Simpson is clearly not buying a single word of Brad's performance. You can tell early on that the court is already losing patience. While we're watching, let me know in the comments whose side you're on, because honestly, at the very start of this, even I wasn't completely sure who was telling the truth. But as this hearing unfolds, things get a lot clearer. Let's dive in and watch how this all plays out.
All right, go ahead. What are we doing?
Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange, there's a pending case where Mr. Kwasny is the defendant of an AMD against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Kwasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Kwasny, victim in this case, not testifying, I will also not testify. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
But does that recording indicate that?
Yes, Your Honor, have either one.
Okay. I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicates he indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to, because that's what I'm being told.
But yes, I understand. I understand that is what's being presented. I also want to indicate that. Go ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge. I indicated to, what's your name?
Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Kwasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know. Are you a lawyer?
I was.
Mr. Lee, no. To my knowledge, no.
So I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself, and I called Mr. Arabo and I asked if Mr. Burgess reached out.
It is not looking good for this guy at all. The moment the prosecutor says, "You might want to stop talking," that's courtroom language for "you're done." And of course, he ignores it and keeps talking anyway. What makes this even worse is that the prosecutor already has video evidence of him trying to tamper with the plea. That's not a misunderstanding. That's not a grey area. That's straight up illegal. It's basically the legal equivalent of leaving fingerprints at a crime scene and then acting surprised when the cops knock on your door. And honestly, I don't know why his attorney is even letting him speak. Every sentence he says just makes things worse. He's not helping his case, he's actively burying it. Witness tampering is not a slap-on-the-wrist offense. It's a felony, and when it's tied to an assault case, it can mean years behind bars. Yet the defense keeps trying to frame this like it's some technical misunderstanding. It's not. You don't get to negotiate testimony. That's black and white illegal. At this point, the only person who thinks he still has a chance is the defendant himself. Judge Simpson isn't buying it, the prosecutor isn't buying it, and the courtroom can see exactly where this is heading. The judge is just sitting back, watching the train wreck unfold in real time.
And discuss any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorneys. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the call. I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea. Not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Kwanzi agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text messages.
I want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right.
Okay.
I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that.
And so I'm gonna give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay.
Okay.
All right.
Thank you, Your Honor.
Thank you. Have you heard him? Or
Just now. Prosecutor and I listened to it together.
okay. All right. I'll recall that. Get Mr. Burkett in here. We'll handle that one. I'm going to take a brief break. We'll handle that one. Then I'll get Mr. Lee out.
Good afternoon, Your Honor. Assistant Prosecuting Attorney on behalf of the people.
I forgot to wear a
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom. Oh, there you
Good
are.
afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Kwasny.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Rubble sent me, as well as Mr. Burgess, and law enforcement as of this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No.
No,
An
Your Honor.
attorney.
It's with Mr. Rubble, the attorney for the victim.
All right. And basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Rubble has additional information or different information, he's welcome to.
Yes. Mr.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me until, and then once I realized what this was, which is an attempt to extort and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time. I was quick enough to get on my computer and record it so that the court is aware of what's going on in the matter where I represent Mr. Kwasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what...
Yeah, this one is completely cut and dry. There's really no way around it. I mean, what was this guy even thinking? Calling the victim's attorney directly is not just desperate, it's reckless on another level. If his own lawyer wouldn't touch it, that should have been his first and final warning. And even if Judge Simpson wanted to give him the benefit of the doubt, the audio of that phone call completely shuts that door. Once that recording exists, the discussion is over. Here's where it gets serious. What he did clearly falls under witness tampering, and depending on how it's framed, possibly extortion, both felonies. You cannot, under any circumstance, try to negotiate with a victim to drop testimony. That's not strategy. That's an attack on the justice system itself. Courts treat that as interference with due process, and they do not play around with it. There is just no scenario where Judge Simpson lets this slide without stacking on additional consequences. And honestly, you don't even need to hear the ruling yet. Just watching Judge Simpson's body language tells you everything. He already sees that this defendant is more guilty than what's even written on paper right now. Let me know what you guys think in the comments, because I'd be shocked if more charges don't follow after this. Based on this guy's behavior alone, it feels inevitable.
Not being a lawyer, using the words a settlement agreement or a plea negotiation, that's what he said to me, and that he had the feeling that Mr. Burgess had not, in fact, made this phone call, so he then called this attorney, and right in the phone call,
Because it would have been unethical for Mr. Burgess to call to try to say my client won't testify in this other matter.
Of course.
If that, right? That's
Well,
what Mr. Burgess may not have done.
and that may very well be, but Mr. Lee indicates that, and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that, Judge, trust me, I know that, but I just wanted to make the record. What, can I just finish though?
Let her finish.
Mr. Lee indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements. the call, it's interrupted. And I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Was there any, did Mr. Burgess call you to try to, see if maybe if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call, because he claims he wanted to come in here today and tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
Your Honor, if I may.
I'd like to say something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Miss Tana.
Mr. Arabo had some trouble with interrupting.
That's only because she's there and I'm not.
Your Honor, I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess, or claims Mr. Arabo was making about extortion. That's not something that people are going to get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying, one of them being Mr. Lee, the other one being Mr. Quadley, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Quadley not testifying in this case before this court. That is what I'm hearing on that call. That is what's concerning to people, and that's what may bring future charges. We're in an early stages. This needs to go to law enforcement. If it has gone to law enforcement now, and we can follow up.
Your Honor, as you know, I'm a defense attorney. I think Ms. Rubio is really grasping at straws here to try to help her client. But here's what it is. It's not a plea. We heard her say plea. A plea means a reduction to something other than what he's being charged with, not a dismissal, which is clearly being indicated in this. Second, what's happened here is you could see clearly there has been a subsequent case filed. I don't know how this slipped between the cracks, because in over 10 years of practicing, I've never seen something like this, where a victim turns into a defendant during a pending case. Never seen anything like this. So Mr. Lee has done this intentionally so that he can one day use it as leverage to contact me or have somebody else contact me or whoever is representing Mr. Quadley, so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Quadley in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Quadley using the leverage that he created. And I don't know how the prosecutor's office allowed this to happen.
Maybe I'm missing something, but I genuinely don't see how this defendant thinks is spinning this in his favor. He's trying to frame it like he was just looking for answers by contacting the victim's attorney. But let's be real, that's not innocent curiosity. That's interference. You don't reach out to the opposing side when you're literally the defendant in the case. And what makes this even more bizarre is that he didn't stop there. He actually went ahead and filed charges against the same victim, clearly trying to flip the roles and muddy the waters. That's not a coincidence. That's chaos by design. I've watched a lot of court hearings, and this is one of the strangest self-sabotage strategies I've seen. What really stands out is the defense's response. I understand it's her job to advocate, but she's treating this like it's normal behavior, and it absolutely is not. This isn't some creative legal maneuver. It's reckless, and at best it looks clueless. At worst, it looks calculated. I'm honestly torn on how Judge Simpson will respond, because this is not something you see every day. But one thing is crystal clear: the more this guy talks, the worse it gets for him. Every explanation just adds another red flag. So what do you guys think? Is this guy completely out of his depth, or is he trying, and failing, to manipulate the system? Either way, it's not going the way he thinks it is.
Isn't monitoring things properly, but this is what's happened. First ever time I've ever seen anything like this, and it needs to be handled. It needs to be handled. It's going to be handled.
Okay.
Can we listen to the call?
Everybody listen to it already.
Hey, can somebody send it to Ms. Weidling, and I will then be more than happy to listen, or if there's an easier way for me to do it, I'll do it. Let's take the defendant back and sort of listen to the call. I can give my decision.
You have to go back.
Court does recall the case of the People's State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Marie Tanhouse, Assistant Prosecuting Attorney on behalf of the people.
And Mary Rubio on behalf of Mr. Lee, who is approaching.
The issue is in this case that, first of all, we're adjourning the hearing over.
I believe we are. That was what I thought we were doing in the beginning.
Well, it's got to stay before me.
I know Mr. Burgess is already going to be here on July 1st. I just wanted to put that out there.
Yes, but I'm not on the.
Oh.
I'm on the bench, but I'm not doing these.
Okay.
With reference to bond in this case, I've listened to the recording. I'm not going to say there's an over-exaggeration or an under-exaggeration. I mean, I think it's relatively clear when somebody very clearly points out an exchange or quid pro quo regarding me not testifying and this other person not testifying, and that is the exchange. I don't know that you get a clearer indication of somebody that is attempting, and especially when they circumvent their attorney, of somebody trying to sort of tamper with and obstruct a case. It couldn't be clearer. I mean, and quite frankly, I don't think there's any design to necessarily frost it over or anything along those lines. I think the idea or what Mr. Lee is saying about what Mr. Burgess wouldn't do is quite frankly just a ruse to hide his own desire to have the exchange that he was speaking with counsel about. Given that, and the court having heard that, with reference to this case, the defendant's bond is hereby ordered revoked based upon the court's hearing of that bond violation.
Your Honor, can I just raise two issues? Before all of this happened, Mr. Lee expressed to me and attempted to express to the court his, as I'm sure the court has gleaned, his displeasure with Mr. Burgess. So I do think that given some of Mr. Lee's allegations against Mr. Burgess, it may be best if someone else is appointed to the case. I know he doesn't want Mr. Burgess.
And that's fine. I don't know whether or not he doesn't want Mr. Burgess or not, because I think, as I'm indicating, I think that notion of Mr. Burgess not doing something and then his checking is simply a ruse for him to try to get the message that I want this quid pro quo, this exchange.
And I'm not accusing Mr. Burgess of anything. I'm just trying to represent what Mr. Lee has told
and
me.
I understand that.
And Mr. Lee is
I think
about jumping out of his skin trying to talk, just so you know.
And so when you talk to Mr. Burgess, if Mr. Burgess, if he believes that that's the appropriate step, he can bring that motion before this court, and the court will hear it in the day that I'm on. Mr. Lee, I will let you talk in a moment, but I'm going to finish this. Revoking your bond because of what is a clear violation of the bond regarding, I mean, I think it's an attempt to try to get indirect contact as well as obstruct these proceedings. Because that was accomplished in the manner it was, and I'm not sure that I can trust you with reference to no context and the like, we're at least going to get through this. I am going to, subject to a hearing, defendant's phone privileges for the jail are also revoked. What did you wish to say, sir?
The thing that my substitute attorney here didn't convey to you was that I told her that I have the evidence with me in hand, that my attorney, Mr. Burgess, was the one that actually said that this was a legal way that we can go about it. And no, I'm not.
You might as well stop right now.
I have the text
because no, I'm going to tell you. I don't know if you're misunderstanding something or what, but you are not. Mr. Burgess has appeared before this court. You are not going to sit here and try to disparage that man, saying that somehow or another, Mr. Burgess represented to you that obstructing a case in this fashion was a legal way to proceed. I'm not going to believe it, and I'm not going to hear you.
I have it.
I'm not going to hear you. I don't know what how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it. But you're not going to sit here and disparage that man. It is not going to happen. I'm done. Bond revoked. Thank you.
Thank you, Your Honor.
Thank you, sir. Appreciate your wait and patience online.
No problem, Your Honor. Are you still on the record? I'm not sure who this kid is or what he's capable of or what sort of messages he can get out to other people. But if the court could put a no contact order because somehow I've become a witness in this matter, I'd appreciate that.
A no contact with you?
Yep. I don't want to be contacted by any third parties. I want out of this thing and I want to be done with it. Didn't ask to be here.
I will add that no contact provision in.
You want of those, Your Honor?
But counsel, why don't you let us know how you really feel? All right. We'll
I
take
think
care of that.
I think the courtroom's been through enough today.
Contact.
Thank you. Appreciate
Thank
it.
you, sir.
Yeah, I've got to admit, I've completely changed my mind on this one. At first, I thought there might be confusion or poor judgment. But once you see Judge Simpson's reaction, it becomes crystal clear. This guy crossed a very serious line. Witness tampering is not some technical mistake. It's one of the most severe things a defendant can do because it strikes directly at the integrity of the justice system. The moment that video was played, you could feel the tone in the courtroom shift. Judge Simpson picked up on every red flag instantly. And honestly, the defense trying to minimize it only made things worse. What stood out to me was the defendant's overall demeanor. He didn't look confused. He didn't look misunderstood. He looked erratic and defensive, and his attitude alone gave away that he knew exactly what he was doing. Courts don't just look at words, they look at behavior, consistency, and intent. And none of that worked in his favor here. Add to that the fact that there are two witnesses contradicting him, and the picture becomes very clear. This wasn't clever. It wasn't strategic. It wasn't some legal gray area. It was reckless, and it was illegal. He wasn't trying to defend himself, he was trying to interfere with the process. So here's the real question. Should Judge Simpson stack new charges on top of what he already has, or are the existing charges enough to bury him? Either way, this case took a turn the defendant clearly wasn't prepared for. Thanks for watching, guys. Let me know what you think.